Hello guys, this is Olayeni, dear Kolola Daniels, and welcome to another episode of Dear Co Talks Law. On this episode of Dear Co Talks Law, I will be talking about the second rule in my first element to be proven in a tort of battery. Do you understand that? In my last class, I talked about the first rule in my first element. What is my first element? The fact that for you to succeed in a claim of battery, there must be physical interference. Do you understand that? For you to succeed in a claim of battery, there must be physical interference. That is the first element to be proven. And then I spoke about the first rule under the first element. What's the first rule? The fact that the slightest touch, the slightest physical contact, do you understand? The slightest physical interference would amount to battery. Now in this class, we are talking about the second rule. And our second rule is whether or not contact can be direct or indirect. When you want to succeed in a claim for battery, can that contact be direct or indirect? That's what we'll be talking about in our class today. But if this is your first time of coming to my class, please make sure that you click the subscribe button. Make sure that you click the notification bell so that anytime I release a video which is going to be of interest to you, you are going to be one of the first set of people to watch the video. And additionally, make sure that you follow me on LinkedIn at Dear Kolola Daniels. But before we go fully into the class, if this is your first time of coming to my channel and yet you have not watched my first video on the thought of battery where I defined the thought of battery, or you have not watched my second video where I talked about the element of the thought of battery and I discussed the first rule under the first element, the first rule which I told you some minutes ago, which is the fact that the slightest contact would amount to battery under the first element of physical interference, which must be proven to succeed in a claim of battery. If you know you've not watched these videos, please, before you continue with this particular video, make sure that you click the description box below. I have kept the links to these videos there. Make sure that you click these videos and watch them. They are very, very important. So now let's go to our class for today. And the rule is that the contact causing the physical interference may be direct or indirect. So it's not a question of whether it is direct or not. The rule is that it can be direct or indirect. First of all, let's start with indirect contact. In the case of R versus Martin, the defendant placed an iron bar across an exit door of a hall, put off the light on the staircase and shouted, "Fire!" In the struggle to escape, several persons were injured. The court held that the defendant was liable for battery. The most obvious argument of the defendant here will be, "I no touch them, oh my lord, me care, waiting, it no concern me, oh, I was not even there, me I was like maybe another place." Do you understand? Like, you know, for there to be battery, there has to be a physical interference, there has to be touch and all that, and then the other party says, "Oh my lord, I did not, I didn't touch them." This is an indirect contact. How? You locked the door to the hallway and then you decided to shout fire, and you know that people could just be a little paranoid. Let's come to Nigeria. In Nigeria, someone is running. It is not your business. You don't even know why he's running, but because he's running, people start following the person. That's how paranoid we are. Do you understand? Now imagine that you are in a place where maybe you don't know the place so well, and then someone then shouts fire. The first thing that comes to your head as a Nigerian, auto exits. First thing, when you don't exit finish, if you can't look back, say, "Hey, what's happening again?" Do you understand what I'm saying? So that was what happened in this case, where the person first of all blocked the doors with iron bars and then shouted fire. And because of how people were paranoid and all that tensed and all that, then they decided to rush towards the door. And you can imagine what that would have done if you were in faculty of law. Imagine that the law annex was locked and then someone shouted fire, or someone shouted something, or snake. Ha! Snake! I will fly. I will fly out of the place. Even if the door is locked, I will fly. I will disappear. But I think you get a picture of what I'm talking about. So the contact need not be direct. In that case, the person was still held to be liable for battery, because although he had not touched them, but he has set in motion what resulted into physical interference of other people. And with that, we go to the second case of PURSELL versus Horn. And I discussed the second case in my last class, where I told you that the defendant threw water on the plaintiff, and then the court held that that was, battery. Now, in this case, the argument there was, but I didn't touch him now. My lord, how would that be battery? The court held, yes, it is battery, regardless of the fact that you were the one who touched him, or you set something in motion to touch him. That something you had set in motion in this case was water. Where you set water, to touch a person, that will still amount to battery. Now, let us go to the direct contact. In the case of Leon versus Metropolis Commissioner, the plaintiff Rastafarian was wrongfully suspected of carrying drugs. The police pulled him, punched him, and kicked him, and then the court held that this was battery. I have a feeling that this particular case has a racial undertone, but I can't say because race wasn't brought into it, but I just have that feeling. Now, but we can see that this is direct. They pulled him off a bus, punched him and kicked him. You can see that the contact was direct, and therefore that will amount to battery. In the case of Ballard versus Metropolitan Police Council as well, the short is MPC. The plaintiff, who were feminists, were attacked by police during a demonstration. One was fell down and carried away unconsciously. Another was fell down and poked with a baton in the stomach and hit over an eye. And then the police hit the head of the third lady with the baton. The court held that there was battery. Also see the case of Freeman versus Home Office. Now, this is a pretty straightforward case. That is the case of Ballard and MPC. Very straightforward. They were feminists, and then during the demonstration, which I'm very sure that they had the right to do, the police still, beat them up. It's could come under constitutional issue and also come under tort at the same time. I don't know if a constitutional case was filed and a constitutional issue raised, but at least we know that a tortious case was filed and the tort of battery was raised, and then the court held that there was battery. I am very sure that the reason they brought it under the tortious claim is so that they can collect damages from the MPC, because the person was fell down and carried away unconsciously. I am very sure the court is going to award a lot in damages. And then the next case that I cited was Freeman versus Home Office. Please and please make sure you get Precious Case app to read all these cases so that you can have a full knowledge on them. I noticed that since I've been teaching, I always use most of English cases because most of the cases you find are English cases. But then I was able to get a little bit of Nigerian cases to help you spice things up a little. In the case of NWANKWA versus AJAEGBO, a servant of the defendant, acting on the defendant's instruction, beat up the plaintiff. The plaintiff brought an action. It was held that, he was liable for trespass to person, and that is a Nigerian case. Also, in the case of AFISI versus AGHAKPE, the policeman beat up the plaintiff. It was held that it was unlawful trespass to the person, and they were liable for damages, assault, and battery. I guess that this is a very straightforward class, but I needed to bring out this element for you to understand that yes, you can have a direct battery, a direct contact, which will amount to battery. Do you understand? And also you can have an indirect battery. In the case of R and Martin, we saw that, which is very, very important for you to, have up here. You can have indirect battery, R and Martin's, PURSELL versus Horn. And as well, you can have direct battery. So as you read for the law of tort, just make sure that you have these cases at the back of your head. Don't let them leave. As you read them, recite them, make them become a part of you. Once the principles and the cases become a part of you, then you are good to go. But then there's also a flip side to it. Now, we've been talking about the fact that yes, when there's a direct touch, you can have battery. But where there is an omission to act, what would amount to battery is where there's a physical interference. You do something, there's an act which is done. But then there is a question as to where there is an omission to act. Would that amount to battery? That is a very quintessential question. And that's the question that I'm going to be answering in my next class where we'll be discussing whether or not omissions will amount to battery. But in this class, I hope you understand that the touch, the physical contact, which could lead to battery could either be direct or indirect, which is the second rule of our first element. First element here being the fact that for you to succeed in a claim for damages, you must have had a physical contact with another person. In the last class, I discussed this in relation to the first rule, which is the fact that the contact, no matter how slight, would amount to battery. In this class, we'll discuss the second rule, the fact that whether or not it is direct or indirect, it will still amount to battery. In our third class, we are going to discuss whether an omission would amount to battery. And I hope you have enjoyed this class. Make sure that you click the subscribe button, make sure that you click the notification bell, and also make sure that you like this video. And lastly, make sure that you follow me on LinkedIn. And with that, I will see you in my next class. Have a wonderful day.